May please your Lordship. Lordship, I like to move I unlisted
I listed I in which matter?
It's in connection with the habeas corpus matter listed in item number 4.
Item number 4.
Yes.
Okay.
Mr. Lordship, I would like to mention from the hearing list on behalf of additional AG, we should grant
Hmm.
item 12, 13.
Hmm.
After 2 weeks, Your Lordship, I have taken the concern of the petitions. The other side, Your Lordship.
12, 13. You are Miss
Hey, Your Lordship.
for the appellants. Are present.
Your Lordship,
Miss
similar prayer for 14 and 15 on behalf of we should grant.
Miss Inahuli,
Yes, Your Lordship.
Learned Council, State Council, representing Miss
We should.
B. Shukri, Learned Additional Advocate General Nagaland, has sought for an adjournment with the consent of the Learned Council for the appellants. Also, when as sought for
2 weeks, Your Lordship.
list these appeals after 2 weeks on a date to be fixed by the office. And who are the, who is the other prayer?
Your Lordship.
12, 13, then?
12, 13, then 14, 15.
Okay. Petition appellants, you are the
Yes. Just
same order. 2 weeks.
Yes, Your Lordship.
14, 15 also.
Yes, Your Lordship. And Your Lordship, similar prayer for 17, 18 and 19 as well, Your Lordship.
Is it?
I've been informed that she's taken the concern of the other party.
Okay. Miss Sinaholi, Learned State Council representing Miss P. Shukri,
This is
Learned Additional Advocate General for the Nagaland for the appellants. Same. It is submitted that consent has been taken from the Learned Council for the respondents to make the prayer. As prayed for, release the appeals after
2 weeks in. And Your Lordship, item 21 and 22 as well, Your Lordship.
21, 22 as well.
Yes, Your Lordship, on her behalf, Your Lordship.
On her behalf,
Yes, Your Lordship, we should create additional wage.
same name.
If I may please. Lordship, if the measure can be fixed on October 8th.
Okay, as short for and as agreed to by Learned Council for the parties, list the appeals. Item 21 and 22.
Yes, Lordship.
Okay, 8th of October.
One more mention, Your Lordship, item number 10.
10.
Your Lordship, I'm sorry, item number 11, yes, 10 also on her behalf, Your Lordship. On Shukri's behalf.
This is criminal appeal,
Yes, Your Lordship.
2022. Yeah. Who is for the petitioner? Item 10? Okay. Mr.
Yakasumi Lordship.
Kasumi Learned Council for the appellant is present. Same. Inaholi on behalf of P. Shukri.
Your Lordship, item 11 as well, Your Lordship, on behalf of E.T. Babong, Your Lordship.
Okay.
I've been informed that he has taken the consent
Okay.
of the other after a week.
After a week. Okay. Miss Inaholi, Learned State Council, representing Miss P. Shukri. Learned Additional Senior. Oh, E.T. Babong, Learned State Council. As same. Mr.
Yakasumi Lordship.
Yakasumi Learned Council for the petition is very consent. Same.
Much obliged, Your Lordship.
For admission, item number 1.
This is Anganwadi Center.
Lordship, may I please your Lordship?
Yes,
I'm appearing for respondent number 3, Lordship,
respondent number 3.
which is a nodal department for implementing this supplementary nutrition program in the state of Nagaland, Lordship. Now, in the last occasion, on date 3/9/2025, this Honorable High Court has passed an order that to file the
Director Social Welfare.
Lordship,
Okay.
Lordship,
Which date you are referring to?
Lordship, on date 3/9/2025,
Yes.
he was directed to file the affidavit in response to the affidavit filed by the state, Lordship, the respondent number 3, in regard to the utilization certificate, Lordship.
1 minute.
Lordship.
Yes, Mr. Yangavati, you are supposed to inform regarding acceptance of utilization certificate. Right, between subject certificate admissions and some modified portion. Released on cost sharing basis for implementation of the various components of the mission. Fulfillment of state northern compliance with the state for fourth quarter of the release will be after adjusting the unspent. As mentioned in the So 2023 to 2024 is settled.
Yes, still 2024. The matter relates to pertains to 2023, but the case we have updated till 2024.
What was the state affidavit?
Hello?
State affidavit on 2/4/2024. 2/4/2024 state affidavit. Oh, this is one. This one. 1 minute. 1 minute.
Respondent number 3 is the Nodal Department and representing respondent number 2 and
No, who filed the affidavit on 2/4/2024?
by respondent number 3.
Lordship.
3.
Yes, Lordship.
1 minute.
That is the utilization certificate.
1 minute. 2/4. 2/4. So we need to copy of the statement of okay, these utilization certificates pertain to which financial year?
No, this is updated, so that's there is a maintenance.
Primarily 2023.
Yes, Lordship.
Huh?
Petition 2020 to 23, Lordship.
2022 and 2000 up to 2023.
Lordship.
Where is your statement? Let us see. Yes, madam, what is your comment on it?
Your Lordship, we have received the report just now, we saw a dead baby fixed for disposal.
Your miss name?
It's better maybe close project, it appears that all the.
Let us have a comment from the petitioner.
Yes.
At whose instance this PL has been
Yes.
initiated. Miss Apila,
Lordship, I'm respondent number 3, Apila Sankam, Lordship.
Miss Heard Miss Api, learned counsel for the petition. Mr. Yangarwati, Learned Central Government Council for the response number 1. Mr. L.T. Sanktam, Learned Additional Advocate General,
Yes.
Nagaland, for the respondent number 2 and 3, 2 and 4, and Miss Apila Sanktam,
Lordship,
Learned Council, for the respondent number 3.
Lordship.
Post up. In the affidavit filed on behalf of the respondent number 3 on 2/4/2024, the respondent number 3 stated that had provided the details with regard to utilization certificates and a manner in which allocated funds had been utilized for supplementary nutrition program SNP for the financial years 2018-2019 to 2022-2023 full stop. It was mentioned that for the financial year 2023-2024, comma, the details were received only up to third quarter, and the preparation of the utilization certificates were under process. Post para. Press quote, comma, by order dated 11/12/2024, comma, directed the Learned Central Government Council to obtain instructions as regards acceptance or otherwise of the utilization certificates submitted on behalf of the state of Nagaland, comma, which were appended to the affidavit filed before this court on 2/4/2024. Post of para. Mr. Yangarwati Learned Central Government Council, appearing for the respondent number 1, has placed a letter bearing number so and so, F number so and so, dated 11/4/2025, received by him from the Undersecretary to the Government of India, Ministry of Women and Child Development, and has submitted that the utilization certificates stroke status of expenditure submitted by the state government of Nagaland has been settled till the financial year 2023-2024. Full stop. Para. For ready reference, the contents of the letter dated the relevant excerpts from the letter dated 11/4/2025 are reproduced here and below. This letter, pencil to pencil. Para, Miss so-and-so, Api, learned counsel appearing for the petitioner, has sought some time to obtain, to complete her instructions with regard to the matter of utilization certificates stated to have been settled till the financial year 2023, that's 2024. And what about the updation?
Lordship, as on 9/2/9/2025, the beneficiaries number totals to 1,33,672 in the Pushan Tracker app, Lordship. That
Nagaland has how many districts?
17, Lordship.
We have data of 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 12.
Lordship, but the new districts are covered by the old districts only as of now, Lordship.
So what is your submission on it? It is complete.
Lordship, still updating is going on, Lordship.
Okay, you place the updated status on the next date.
Lordship.
We have perused the contents of the affidavit filed on behalf of the respondent number 3 with regard to compliance of the direction made in order dated 19/2/2025. Full stop. By the order dated 19/2/2025, the respondent number 3 was granted time to place up-to-date status report as regards uploading and upgradation of the Aadhaar cards of the beneficiaries in the portion tracker application. Full stop.
Lordship, if I may be allowed to mention, on date 17 June 2025, I have filed in the form of affidavit, Lordship, with regard to the uploading of the beneficiaries in the Pushan Tracker app, Lordship.
You have not heard what I have dictated.
Lordship.
In the affidavit filed on 18/6/2025, the respondent number 3 has stated that at present, there are 380 Anganwadi centers across the state of Nagaland. Full stop. The affidavit has further stated that total beneficiaries, the names of beneficiaries updated and uploaded in the portion tracker application stroke dashboard as on 31/5/2025, are 1,30,188. Post. Para. Miss Sanctum Learned Council appearing for the respond number 3 has submitted that the process of verification and uploading of the names of beneficiaries in a portion tracker application stroke dashboard is in progress, and she will be able to place the updated status on the next date of listing. Yes?
Lordship.
As sought for by Ms. Safi, Learned Counsel for the petitioner, and Ms. Sanctum, Learned Counsel for the respond number 3, list the appeal after 4 weeks. Yes.
Obliged, Lordship.
For admission, item number 2.
May it please, Your Lordships.
Yes.
Your Lordships may kindly peruse the order dated 3/9/2025.
Mean PL for the mean PL.
How do we have filed an affidavit this morning if the affidavit may be called for?
Main PL for the main PL copy. Main PL copy.
The main petition. These are all the court orders.
Not always the main PL copy.
What if there is a sumo to PIL, what's with this? No application.
No, I need the names of the parties.
What's with the orders, the court's orders?
Court's orders does not indicate who are the parties. We have the order sheet in this file only. What is the main PIL? Whatever people show more, what is the name of the parties serially? Because parties are being added from time to
Yes,
time.
Lord. Yes, Lord.
There should be a list of parties, right? In a separate piece, because it is very difficult to. We don't know. We have to be.
Your Lordships, perhaps one of my learned friends at the bar can furnish a copy of one order with all the parties' names.
That is what at least to direct.
Yes.
We
Yes, Your Lord.
Yes.
We need at least some assistance.
Latest order.
Certificate copy will come. Madam, do you have the, can download the name of the parties? So that we can keep it here.
So this only petitioner is 113 to retest. Complete responsibility.
Give a print. It's okay. Okay. Mr. Jimomi, you are amicus.
Yes, my lord.
Okay,
Your Lordship, the order dated 3/9/2025. That was the last order.
we'll come to it.
Yes, madam.
CGC appears. in this
Yes,
case?
ma'am.
She says also.
Lordship, I'm representing 128, even the unit lordship.
Oh.
One, okay, you
One.
represent one.
Yes, Lord.
Two,
2 and 8, Lordship. 2 and
Eight.
8 are NHIDC.
Let me try this.
okay,
I represent 13 and 14.
13 and 14.
Yes.
Okay. Okay,
Chief correspondent number 10.
10, okay. Let us write the names first. Mr. A. Jimomi, learned amicus curiae for the petitioner. Mr. Moa Jamir, learned standing counsel, who has appeared for the respondent number 1, 2, and 8. Mr. Im T. Im Chong, learned additional advocate general, Nagaland, for the state respondents. 3
3 to 7.
3 to 7, 11, 12. And Mr. N. Mojui, learned counsel for the respondent number 13 and 14. Before that, Miss
Kokla.
Yuka Kopka, learned counsel for the respondent number 10. Okay. Yes,
Order dated 3/9/25, my lord.
3/9/2020.
Yes, my lord.
This is regarding the stretch of 26 kilometer
Yes, my lord. Yes.
from Kohima to Mao.
Yes, my lord. Yes, my lord.
Mao is the Nagaland border.
The road is in very bad condition, my lord.
No, Mao is the last Nagaland border.
Yes, yes, on the Manipur Nagaland border. Here.
Okay.
Maugi. Yes.
Now 3/9/2025. Okay. So,
Yes, my lord.
the stretch of.
My lord can come straight to paragraph 2. Start from paragraph 2, my lord.
Okay, there is a stretch of 100 meters
Yes, my lord.
where it had collapsed. And what
Just-
was the direction or observation made in the order?
And my lord, we see paragraph 3 also, my lord. There's a further observation in paragraph 3.
Or who have been given the task as per number 13 and 14?
No, 13.
Yes, my lord.
No,
It's one number 13.
He's here. Contractor is here.
He was supposed to complete the work by 31st May.
Yes, Lordship. Lordship, the NHIDC said that's
One
one
minute. Let me read the affidavit. Personal appearances are called for.
Yes, Lord.
Have they come?
Yes.
Yes. Who is a representative for the NHIDCL?
General Manager.
Yes. Yes, please, sir. Come forward. Yes. What is your call on it?
I'm Anand Kumar,
Yes.
Deputy General Manager, PMU Jakhama NHIDC, Your Honor.
Yes. What has happened now? What is the present status?
Present
Regarding
status,
execution of the contract, that part of the contract?
there have been 2 points. One is 100-meter sinking area.
Yes.
That has been temporarily restored, sir. And traffic has been allowed from 23rd of August on that stretch. And 3rd of September, we have allowed the 6 wheel truck also. The traffic is going on smoothly on that stretch. As soon as the weather permits, we will do the bituminous work, because bituminous work cannot be carried out, Your Honor, in the rainy season, wet conditions. Otherwise, stretch is motorable, vehicle is moving
Okay.
on that 100-meter stretch, Your Honor.
And this will be part of the national highway for of that stretch of 26.7 kilometer, or
Yes,
is
it
there
is a part of the,
any proposal for alternative route?
that is going on, it will take some time, but presently it is part of the 26-kilometer stretch only.
Yes, Mr. Jibomi?
Yes, my lord. Now, my lord, two things. Firstly, the entire contract was supposed to be completed by 31st of May. It has not been completed. Secondly, as far as this 100-meter stretch of road is concerned, what has been done by the NHAI is just a temporary measure. It's a restoration. But ideally what we would like to look at, Your Lordships, is a permanent solution. And for that, they have already acquired land. So what is required to be done now, my lords, is a concrete action plan about how they are going to complete the contract for the entire stretch, including the 100-meter sinking area. A concrete action plan, my lords. And in this regard, on the last occasion, the NHAI made a submission that they had constituted an expert committee. The committee has already submitted its report. That has also been noted by this honorable court, Your Lordship. But
Yes.
therefore, an action plan now, my lord.
Yes, Mr. Jamir? What is your reply in the affidavit regarding that formation of the expert group and their suggestions?
We have also submitted the expert committee report. That is only pertaining to the temporary temporary measures. We have also stated in the affidavit that the permanent measures can be taken up only after we conduct a survey of the on the spot.
That was regarding the alternative proposal. That is not part of the terms of reference of the expert body.
No, the expert committee has only suggested only for a temporary measure only. Permanent can be carried out only as and when the condition permits one.
And so far, any action regarding the contractor who delayed the work?
We have been issuing notice to the contractor. In fact, notice intention to terminate one of the contractor.
Intention to?
Terminate one.
Intention to?
Terminate.
Terminate. What is intention to terminate?
As per clause of the contract.
It is to be a show cause to terminate, not intention to terminate.
That is the
Who is the representative from the respondent number 13? Yes, why your date of completion is being extended from time to time? We are in September.
So due to the unwanted weather conditions, sometimes we fail to comply, and of course there are some people.
Was it unwanted condition, inclement weather in April, May?
So in consultation with the authority in also sometimes of course the NHID department also instructs us.
I have read in the newspaper only in September it is untimely rain. Whether it was untimely rain in April, May.
Yes, sir. The weather reports in the April. And this is backup from the north. Ministry of Work for the highway. That backup the VDM should not be done during in on-wet surface. BDM and BC, the blacktop will be found. Let's come to page 45 of the affidavit.
Whose affidavit?
The NHS 288 responded number 288, which are filed this morning, this morning, yes. Page 45. At clause 501.5.1.
This temporary restoration, is it part of the contract work or No, it is a separate one. So what is the extent of completion? By the respondent number
Progress is 62%.
62. On the earlier date, as per Mr. Jamir, 70%. It has
What if that has
been reduced.
Which item has come to 70%?
It is going down instead of going up.
Actually, the work experience is too low for that, but considering the work which they are experiencing, even in the damage area, we are working through it, that comes to 70%. Lordship, one aspect of the matter, Lordship.
Now, intention to terminate is one thing. It might be terminated. That is another thing. But what about the work? Have you given any deadline?
We have
While
given
showing an intention to terminate.
not only intention to terminate, Your Honor, we have issued slow progress notices. We have conducted meeting. He was also summoned at Delhi headquarters NHADCL to expedite the progress and quality work so that the work can become. This is part of the affidavit. Minutes of meetings are enclosed in the affidavit, Your Honor.
Okay, let me. Who is undertaking that temporary restoration? Neeraj Cement.
Needed seconds.
Also heard Mr. Anand
Anand Kumar.
Kumar, Deputy General Manager, PMU.
Project Management Unit, PMU, Jakhama.
Jakhama, okay. PP Project Management Unit, PMU, Jakhama, NHIDCL. And Mr.
So my name is Bechupa, and I'm the proprietor of this BRC.
Okay, proprietor. Messrs. Bechupa, Rose and Company.
Yes.
Within bracket, correspond number 3. Post of 13. This code on 3/9/2025, learned amicus Curie had highlighted that in a stretch of 100 meters within 26.7 kilometer stretch of the national highway between Kohima Mao there was a landslide as a result. Seat stretch of 100 meters had collapsed. In response, no. an affidavit has been filed today on behalf of the respondent number 228, 2 and 8, 2 and 8. So in the affidavit, it has been stated that there was complete collapse in a stretch of 130-meter near Fesama at chainage 191 plus 950 to chainage 192 plus 080. Also, the restoration work for the state streets has been entrusted to one Messrs. Needles Cement Structures Limited. Post-op. The sinking area, it has been stated that the sinking area has been partially restored and open for light motor vehicles on 23/8/2025. And for 6-wheeler trucks up to 20 tons gross weight from 3/9/2025 onwards. Post-op. A traffic advisory issued by the Deputy Commissioner Kohima on 23/8/2025 has been appended to the affidavit. Post-op. From the traffic advisory issued by the Deputy Commissioner Kohima, it is noticed that in view of partial restoration of the affected portion of the National Highway 2 within bracket Kohima to Mau near Fesama, one-way traffic of light motor vehicles has been opened under strict regulations. The advisory, however, has suspended the movement of heavy vehicles, including water tankers, paramilitary vehicles, etc., and all types of heavy commercial passenger vehicles till further notice. Post-op. On a query made to Mr. Anand Kumar, he has stated that the restoration works are still in progress. For further upgradation on the road. Post-op. He has submitted that the restoration works are expected to be complete within the stretch of the road under reference. Within what time?
By November.
100 meter, I am saying, not respond number 13. It will take November, up to November, 2 months, 100 meters.
The soil laying has to be done. The hill portion is very vulnerable and slides are coming in. That has to be.
Okay, in view of the, yes, Mr. Amagus.
Yes, my lord. No, my lord will see from the affidavit which has been filed today, the land which has been acquired is not actually an alternative route, but it is adjoining the sinking area. So the new road or the upgradation or strengthening of the road will happen in the same stretch. So an action plan must be provided, Your Lordship. It's not just about filling the sinking area and then restoring the road.
No, we are into sinking here. We'll come to the other aspect later on.
Yes, my lord.
It has been submitted on behalf of NHI DCL that this particular stage, 100 or 130 meter.
Yes, my lord.
The restoration will be over only by November only.
Yes, my lord. My lord, I'm not an expert as far as engineering is
also not
concerned.
expert because
Yes, my lord.
you have to see also the soil condition.
Yes, my lord. True, my lord.
How much was the sinkage?
Yes, my lord.
We are not experts.
Yes, my lord. That's true, my lord.
So, but try to expedite at least.
We'll do you.
But you give a up-to-date report by end of October. But that how much you have achieved?
Your Honor. Yes.
Okay. Within the month of November 2025, first of all, he has, however, undertaken to submit an up-to-date progress report by the end of October 2025. This is regarding 100 or 30 meter. Now, what is the contract work with respond number 13?
Yes, Lordship, the stress comes from Kesamaki.
This is not this area.
Even if you go this area, the Kesama, that's right, it was under our scope.
But it has been given, restoration has been
Yes,
given.
now
After restoration, what will be his role?
yes, no, there will be another different work for it, for that man.
This 130 meter will be detached from his scope.
Okay.
He will pass.
Okay, huge tax, so it is out of his purview.
Yes,
Now, what remains then?
the remaining portion.
What difficult terrain?
No, Lordship, as per the affidavit filed by the NHIDC Lordship, which we were supposed to place the documents, Lordship, but since they have already placed, and the affidavit is before his Lordship.
That is a Porso, paragraph 3, only 62%.
Yes, Lord. No,
It appears to be a Porso.
actually, it's 70% Lordship, or more.
We go by the certificate.
No, Lordship. Certificate. No, there's no certificate.
Paragraph 3, their table, we construe it to be a certificate.
Paragraph 2 of the affidavit.
The table.
The table,
My engineers can allow to explain the activities of the respondent number 30 Lordship. We have appointed an independent authority who sees and supervise the work Lordship. Basing on the report submitted by the authority engineer, we have filed this affidavit Lordship.
1 minute. Respondent number 13 was appointed pursuant to an NIT?
Order was issued to me on March 7th of this year.
March 7 this year.
Yes,
This is maintenance contract.
yes.
Maintenance contract.
So we will give them,
So this is your, is from Lehrigate to Kiguama?
yes. No.
Huh?
Mauget. No, initially there was a.
Kiguama village to Mauget.
No, from Hesamak till Mauget.
From Larry Gate, starting point of the NHI is here 26.7 kilometer you have to know. The total stretch was included in their STMC contract. This maintenance contract.
This is a maintenance contract. Now this, the stretch is from Lehrigate to Kiguama or Kiguama to Mao, because there are two NITs for maintenance. Those are separate. Okay. Where is his contract? What is the nature of the contract? Please. It transpires that the respondent number 13 has been awarded short-term maintenance contract for balance works of NH 39 within bracket new NH 02 from Kohima to Mao stretch from KM 185.540 to KM 212.334, having a length of 26.794 kilometer on percentage rate and work order basis. Post op. The contract price is 15.84 crore as per the work order dated 27/2/2025. Post of the LOA was issued on 19/2/2025 with a projected date of completion 30/05/2025. Post of. Para on deliberation on previous dates, it is found that the completion of the awarded work has been delayed substantially. Post of. Para as per the affidavit filed on behalf of the NHIDCL authorities today, to get a photocopy, otherwise she will find it difficult. The respondent number 13 has achieved progress to the extent of 62% as on 15/9/2025. Post op in paragraph 3 of the affidavit, the details of the balance work have been mentioned. Post op. Para. Insofar as the action contemplated by the NHIDCL authorities against the respondent number 13 comma it is mentioned that meetings were held during April, August, and September to sensitize the respondent number 13 to complete the works by mobilizing more manpower and machinery at site with highest quality standards. Slow progress notices have been served on the respondent number 13 on 9/4/2025 and 28/6/2025 for the delay in completing the contract work for failure to meet the deadlines.
Go to paragraph 6 of the article. They're asking us to maintain the highest quality, but the guideline.
I mean, I'm going one by one paragraph. I have not reached paragraph 6 yet. In addition, verbal directions have been issued for early completion of the contract work. Posto. It has further been highlighted that since major portions of the scope of work pertains to blacktopping within bracket bituminous work activity, there are also hindrances to complete the work due to early onset of monsoon, which is continuing in the month of September. It has been projected that in such wet conditions, it is not conducive for such blacktopping within bracket bituminous activities in road works. It is further stated that as soon as the weather conditions improve, the contractor, that is a respondent number 13, would be asked to complete the balance works by 25/11/2025. We are having regard to the above projections made on behalf of the respondent NHI DCL authorities, we also observe that the NHI DCL authorities shall furnish up-to-date progress report received up to the end of October on the next date of listing. Yes. Third one, regarding land. We don't know what is now weather God is not permitting.
Yes, my lord.
That we can understand.
Yes, my lord. Yes.
Now, your submission regarding acquisition of land.
Yes, my lord. That has been done already, my lord.
Is
It is already. Yes.
Is it within the plan? Within this 100 meter stage?
Yes.
But this is not very conducive for all times to come, or what?
Please, we have
No.
statute plan.
No, this 100 meter where the sinking happened,
This one.
is it not very conducive for all times to come? That is why you have acquired land or what? For what reason?
We have realigned the road,
You have realigned now.
realigned the road
Ah.
towards the hillside. Earlier we tried towards valley side, we have acquired land towards valley side also, but it could not succeed. So we have gone towards the hillside now, and it is succeeding.
So this 100 meter stage or 130 meter stage, it is in the valley side.
Now we have gone towards the hillside, the road which we have opened, recently opened for the trucks also, for the light motor vehicle also, it towards the hill. Earlier alignment was towards valley side, now we have gone towards hillside.
So towards hillside, you have acquired land. Meaning thereby, this is the road, this is the hill.
Yes, Your Honor.
I am not understanding the actual picture. I cannot visualize sitting here.
Your Lordship, what has happened is this stretch of 100, 130 meters.
Let us have a
The hillside.
visual representation for me.
Okay. On the hillside, more land has been acquired on the hillside along this stretch.
We have got photographs.
Let us have a photograph.
Yes.
Very well, madam.
We always go by I always go by photograph.
Yes, madam.
Picture does not lie.
Yes. Photographs do not lie, madam. Yes.
In continuous monitoring, it's not very clear. When I'll not be here. One who is monitoring, saying in Gauhati, it is a chief justice. It always comes over him. So it is a continuing force for us. We can't.
What do we have final affidavit on the 4-6? We have enclosed some photographs.
Yes.
So you mean that there will be cutting of hills? And it will go towards hill and there will be more space on the other side. You leave so that if something happens also sinking, there will be more open space towards the open end. One side will be hill, the other side will be open space. Sufficient enough space. So you have realigned the road towards the hillside.
Put drone video also if you want to see.
Okay, let us have. This is our affidavit.
This is final one.
My esteemed sister knows, but I don't know. Okay. This is towards. Okay.
The photographs are there in the affidavit filed on 9/6, madam.
I have seen. Let us have a pragmatic view. I think that is more
Yes,
practical.
madam.
That
Yes,
is more
madam.
practical. So has this affidavit address on that issue? Which part? Which paragraph? Because 3/9/2025 order.
Even in the affidavit file on 28/2025.
Okay. Let us have a up to this status in the next affidavit.
Okay.
Because the other two aspects are to be highlighted in the next affidavit, up-to-date progress achieved up to end of October. So you address that issue also in the next affidavit. Yes, Mr. Jimom.
Yes, my lord, that's fine. Let him do that, man.
Mr. Anand Kumar, Mr. Anand Kumar has further submitted that the process of acquiring land for realignment of the National Highway 2 has achieved satisfactory progress, and he will be able to place on record the progress to extent of progress achieved in the next affidavit we file. So November first week.
Lordship, at direction may also be responded and then the authority engineer to file the report. Because Lordship, we work as well.
He is part of NHIDCL or?
We have engaged him to supervise this work for inspection of this.
And we work in consultation with him.
Hmm.
So his presence is super Lordship, and his affidavit will be.
Who is representing him?
Respondent 10.
Respondent number 10. Yes, Miss. You also file an affidavit, right? The respondent number 10, he is
Authority engineer.
the authority engineer. Shall also file his affidavit on the on the first first two aspects indicated above, on or before the next date of listing. He will address on the first 2 points, not on the land.
Yes, yes, my lord.
List the PL on first Wednesday is holiday. November, first Wednesday is holiday. So 12th of November.
Much obliged, my lords.
Madam, take this over. Now, NDPS.
For admission, item number 3.
Yes, state affidavit.
So I found this affidavit this morning, Your Lordship.
Good.
So this matter.
Where is it? No, we'll take up.
Which-
And do you have the records? So this is PIT and NDPS.
My lord, yes, correct. NDPS.
So when he was preventively detained,
My lord, I was arrested on 25 February.
where is the detention order?
Detention order was issued on 9/5/2025.
Page?
Huh? Page 53.
Page 53.
The initial detention order was.
1 minute. 9/5.
Correct, madam.
And you were taken into custody when?
I was already in the custody February.
Already in the custody.
February 25
Since
February.
February
25 February 2025. Till date.
20 February
25 February 2025.
Okay. When was the proposal, madam?
Proposal was on 5 May.
5 May. Then 9th May is the detention order. Then grounds of detention was communicated to you when?
On, my lord, communication was on 13 May.
1 minute. Detention order, date 9/5.
9/5/2025.
Detention. Then the
Proposal was 5 March
2025.
Proposal was 5 March.
5 March 2025.
Page, any idea?
Page 41 to 44, my lord.
Proposal. You were in custody in connection with another case.
Yes, my lord. Police case, my lord.
Police case.
Yes.
When? Since 25
My lord, 25 February 2025.
in custody.
Yes, my lord.
Arrest and custody.
Yes.
Okay. Now, these are served when?
Detention was served on me on 13th May
13 May.
2025.
Copy served.
Yes, ma'am.
Along with grounds of detention.
Yes.
And
But
other records?
no.
No.
But the problem was.
One by one, I'll ask. I'll ask. You
Yeah,
have that.
sure.
Let me have my very first
Fine.
copy served. No supporting document. The supporting document.
Correct. Police documents. All
Police document served.
Yeah.
Supporting document.
In English.
Okay, I'll ask. Supporting documents. Police documents. Regarding that police case.
Yes.
Police case. Served. Then any representation?
Since it was in English.
No.
That's why I
Any submitted or not submitted?
Correct.
Yes or no?
Yes.
Yes. When?
19 May 2025.
19 May. Representation.
Yes.
Before which authorities?
Before the detaining authority.
The only detaining authority?
Yes.
Only?
Yes. Because the language was not understood by me. I didn't.
Where is your copy of the representation?
Page 69, 59, 51, 59.
59.
But page 61.
Page 59.
61 to
61, not
61,
61.
62.
61. Okay. It was disposed of as per their affidavit?
Reply was given to me saying that, yes, since you don't know English, so we are furnishing you in vernacular. Now that vernacular was only in respect of detention, not other supporting documents. That's why I have filed another representation. Because Lordship will appreciate.
No, your representation is on what aspect?
Lordship may kindly see come to page 61. That's what I wanted to show. Page 61. And I check.
So you said that language is not understood by me, so you provide me a complete copy on all in translated form.
Correct.
Right?
That was not.
To submit an effective representation.
Yes.
That is what
That's
you're.
the point. That is the
Representation.
because there are judgments.
So that is that the documents, English is a language which is not understandable by you. So you provide me the documents in a language understandable by you. My language, which I understand, is Nagamese and
Poma Naga dialect.
Pome Naga dialect.
He doesn't study even ABC classroom. He didn't go to school.
Pome Naga. It has a script or not?
Very much.
It has a script.
It is a recognized.
Okay. Okay. Poime
Naga dialect.
Naga. Or otherwise, Nagamese has any script?
No, we use English script.
Huh?
English script only.
English.
Yes.
Dialect. It has a script? Are you sure? Script. It has a
We were
script.
using only English script, I think.
Nagamese uses what script?
Nagamese also Nagamese also we use English script. So also our Angami we all use
Yes,
English script.
correct.
Yes.
Script correct.
Yes.
Script. I'm saying that script because in Bengali or in Assamese it has a different script.
English script.
Right. But Nagamese is still in English script.
Yes.
You'll not be able to understand Nagamese by reading it in English script.
you know,
Now, the next question is Poime Naga dialect has a script.
no.
Then,
English,
then,
no, Lordship will appreciate.
I'm just asking query. Now, after this representation
Yes.
that provide me, because this is also, if let us have the representation.
Yes.
We'll come to the other aspect later on. Because this is in compliance of Article 22.
Correct.
5
That-
to submit an effective representation.
Yes.
Right? So, in a language known to me,
Yes.
that is Pomai,
Yes. Poma and Naga.
Naga dialect, or at least in Manipuri.
Yes.
Manipuri has a script.
Yes. They have a script.
They have a
They have a
script.
script.
So you can read Manipuri.
Yes.
Nagami is also in English.
Yes.
Pome Naga is also in English. Right?
Correct.
So if you don't know ABCD, you cannot read that also.
Cannot. He didn't study in class 1.
Okay. So only alternative is Manipuri. If you can read,
Either
can you read Manipuri?
either Poma and Naga dialect or
No. If that,
No.
well, sir, be practical. Be practical. If Poem and Naga, yes. I know you in English. In Poem and Naga, moi jane. Right.
if someone
That is to be written in English. If you don't know English, how can you read?
see,
Right. Do you know Manipuri? To read and write.
eat in the evening. What is what in the
Because see, for example, Nagamis, we use English script.
correct.
So Moi, so MOI. So if he cannot read ABC, how can he read that also?
Someone that's why I'm saying
Hmm.
with the assistance of my friend, I have said that in my represent with the assistance of my friend.
That is like,
With the assistance of my friend, I have clearly reflected because he didn't
that
study in class-
assistance, no, that assistance can also be obtained for English also. What I am conveying, have you understood? Have you understood what I am trying to convey?
Yes.
That if you want translator or interpreter for English, you also need interpreter for Poime or Manipuri or Nagamis. Right?
I agree.
So to that extent, slightly, whether your representation has been addressed.
No.
What did they say?
Lordship will see.
What did they say in their affidavit?
Now they say, they have furnished the detention order translated into Pomai dialect. But the supporting documents were not furnished to me in Pomai dialect, only detention. So therefore, I have submitted another representation. No, unless you provide me supporting documents which constitute the basis to issue detention, how does I know the contents, the intent, the subjective? So that is what I have submitted another representation. So till now, they have not provided the translated copy.
Where is your ground of detention?
Basically, I have challenged the detention order on 3 grounds. One is confirmation order was not issued within 3 months from the initial date of detention. 1.
That is section 9.
Correct.
Section 9F or what? First ground is confirmation.
Order not issued within 3 months of the initial detention order.
Was not issued within 3 months.
Yes.
Let us have the NDPS Act.
That next, my lord,
Within 1 minute. Period of
3 months.
3 months from the, okay. What is the provision?
My lord,
Section 9,
section.
F or D or what?
Just a moment.
The case has been made under the asylum. Every case where the advisory board has reported that there is in each of insufficient cause or professor on contracting that continue. God, there is, where is the provision for 3 months?
I'll show the
Because-
pronouncements of Supreme Court Justice.
No, to the extent I know as part of PIT NDPS Act that it is the advisory board who has to give its opinion within a stipulated period.
Correct.
You say from the date of detention order.
Correct. That is what Supreme Court says.
Okay, let us see. Any statutory provision?
There is no specific date. But they have Supreme Court said it, unless that is done, it is violated of Article 22, Clause 5.
Advisory board to which? I'm not calling was.
There is
11 works. 11 works. When was the confirmation order?
confirmation order is, my lord, 12/8/2025.
And detention order is
9/5/2025.
where is the judgment?
And my lord, next ground. Next ground is the detention order and the ground of detention was not supplied in the language understood by the detainee. I'll show the judgment.
No, there are plenty, but
Yes,
the
thank you.
practical difficulty here, we are highlighting how to overcome it.
Lordship will see once I.
In both the cases,
Just read it.
it is settled. But difficulty is you don't know to read Pome script because it is in English. Then Manipuri, if you have not read up to anything, then Pome or Nagamis or English, everything is same for you.
Then even otherwise, another ground, my lord.
Yes.
Not mentioning the grounds of detention, that there was likelihood of the detainee being released on bail. This, your lordship also has for this, I have your lordship's own judgment on this principle.
Okay. Bail.
My
Hard
lord,
one.
my lord.
He was already in custody.
Yes, my lord and Justice Devasis had passed the, I have the judgment. Because in that also, when the detainee was already in custody, in the supporting document, either in the ground of detention or order, they have not reflected that he is already in custody and likely with nothing. So that means without subjective satisfaction, without application of mind. That is what the judgment says, my lord.
Now, 3 months, where is that?
My lord, I'll just show judgment.
Not 3 months, yes.
Yes, I have supplied the citation list. SCC 1974, volume 3.
1974.
SCC 1974, volume 3. Page 50, my lord, page 4. I'll just come to the relevant paragraph of it. Para 8, my lord. Page 55. May I read it, my lord? Para 8. It is not disputed that in the present case, the order or the decision confirming the detention order and the continuation of the petitioner's detention thereunder was made or taken 3 days after expiry of the period of 3 months. That being so, there was, in view of the decisions referred to earlier, no valid confirmation and continuation, with the result that the petitioner detention after the expiry of the period of 3 months became illegal, since it was not in compliance with section 12(1). In this view, it is not necessary to consider the other two contentions
Right.
argued by the council.
Now, the act is there is West Bengal Prevention of Violent Activities Act 1970. Right.
Then
No, let us see the provision first.
I'll-
We cannot pick up this. Let us see the,
That-
please take up the book.
I'm saying.
Detention order was served when?
Served on 30th May 2025. I have given on the same point, I have given our own hyper judgment, which was filed by the Chief Justice, the then Chief Justice, another bench, another judge.
No, I want to know the logic. Just I'm.
Yes, ma'am.
In the correctly or no, this one.
next judgment passed by High Court is
One-
more specific, more specific.
Let me complete it. Constitution. When was the advisory board opinion? Where is the confirmation order?
My lord, page 57, my lord. Confirmation was page 57 and it was issued on 12.
Where is the advisory board opinion? Please tell me. Your representation was before detaining authority.
Correct.
Detaining authority disposed of the representation?
Yes, Your Lordship.
Where?
Your Lordship, it's in my counter files this morning, Your Lordship. It starts from page 23.
23.
Oh, Your Lordship, page 21.
Page 21.
Your Lordship.
This is execution.
Starts with. Annexure D, page 22. Which basically the representation was for furnishing the grounds of detention, all the relevant documents in Kohima. So this was, yes, Your Lordship. So this was the.
Okay, we'll come back. Because Article 22 says advisory board has to give an opinion within 3 months. Right. But here advisory board has given its opinion within 3 months. Now question is regarding what you have argued is confirmation order. It has been passed beyond 3 months from the date of detention dated 9/5/2025. Right? It is your submission. So I'm trying to understand the logic.
Well, like
Better to understand in your presence rather than in your absence.
But we are after it. So,
Mr. Joe, just a minute, let me read this reasoning.
Yes, yes, fine. Your Lordship, send paragraph 9, that will be more clearer. No, Mother, this is a clearer, the confusion that
Let
we
me,
have.
let me. It is para 6. It was not explicit in the provision. We have this, that means 1974,
Have you supplied 1974?
TSS. The no law for 1940 self-supervised detention, the person for a longer period than 3 months, unless an advisory board consisting of person, so, and judges was reported before an expiration was 8 period of 3 months. Said there is needs to be sufficient source for such detention. Right? No, opinion. Within 3 months. This is the date. Right. Then the reasoning things. It is independent, but the interpretation is the same. Does detention restraint on the detention order can only really continue for 3 months? If you are receiving advisory board's report, government wants to continue the detention of the finder for a further period. Has got to make an order and utility to confirm the order and continue the detention for without such an order detention issue in the order is not beyond the period of 3 months. Though is the interpretation. Though therefore section 12 does not in express terms lay down that the decision to confirm the detention order and to continue thereafter the detention is to be made before the expiry of 3 months. Such a time limit is implicit in the sanction. The reason is plain. The government can keep a person under detention for a day longer than 3 months if the report of the board does not justify the detention. The continuation of detention beyond 3 months can only be made upon the government obtaining a report showing sufficiency of force before the expiry of the period of 3 months. It is to enable the detaining authority to continue detention beyond 3 months when detention must end. That the Act provides 30 days within which reference has to be made and 10 weeks within which a report has to be obtained. There is 11 weeks. This one. A few weeks left thereafter give time to the government to decide whether or not the detention order should be confirmed and detention thereafter should be continued. If there is no such decision to confirm the order and to continue the detention thereafter, detention has to come to end on the expiry of the 3 months from the date of detention. Such an order decision has therefore to be made within the period of 3 months. So without such an order, detention would otherwise be legally. So when something has come to an end, then thereafter we cannot continue it.
So it has to be within the 3 months.
So this is interpreted, not in the Constitution or in the PIT and NDPS. So this reasoning might apply in
Because by the time they
this.
this, it
But they took time from 27 to they took the time for next 3 weeks. They did not decide to confirm. They were sitting on it.
within the 3 months.
And that's it.
Yes.
Right. Yes, what is the next? What is the next decision you say?
Lordship, I'll just show our own hyper judgment.
Yes.
Gauhati. Next judgment. W criminal 1723.
Provide us copies.
This was passed by the then Chief Justice Sandeep Mehta and Justice Mitali Thakur. my lord, similar, this is with NDPS, my lord. My lord, there is no paragraph, so come, Lordship, may kindly come to page 5. First paragraph. This is with NDPS, same case, my lord. And here, Supreme Court judgment has been referred as so on.
Understood.
Page 5,
This point.
yes.
Below this.
The situation in the case at hand is alarming to say the least because the detainee has been kept behind bars for a period of more than 8 months. Exactly, I'm also 8 months now. 8 months without the initial detention order being confirmed. Every moment of custody of the detainee beyond the period of 3 months from the date of initial order of detention without the order of confirmation being passed amounts to illegal detention, pure and simple. And my lord, in this court has given an order for minimum compensation for illegal detentions. So in our case also, I'm in jail since February. This is 8 months now, my lord. Squarely covered. So therefore, confusion is that whether the 3 months will run on the recommendation of advisory or not, but the initial detention order, my lord.
Oh, no, that has been interpreted by Supreme Court.
Yes, my lord.
In that case.
Lord is aware. Now, Lord, which therefore, as I have said in this case, a symbolic compensation also has been ordered for this for illegal detention, my lord. In this our own high court justice. If Lord should be satisfied on that point, then I'll come to the next point, my lord.
1 minute.
My lord, on the same principle, if I may be allowed to show the Supreme Court judgment, 1978.
Please.
My lord, 1978, volume 2. I'll just come straight to relevant paragraph, page 513, 513, paragraph 9 and 10. May I read it, my lord? For paragraph 9, fourth last sentence, my lord. I'll just read relevant paragraph. Fourth last sentence. The law does not lend its authority to the continuance of the detention even for a day more than the initial period of 3 months if the government does not take a decision for that purpose on the report of the advisory board within 3 months of the commencement of the detention.
Yes, madam. On this point, you got the advisory board report on 23/7/2025, right? 23/7. Then if you take the order of detention 9/5/2025, then the 3 months period expires on, say, 8/8/2025. Then your confirmation order is on 12/8/2025.
And serve on me.
Right.
Serve on
Then
me.
the interpretation given by the Supreme Court is that so you had the period from 23/7/2025 to 8/8/2025 either to confirm or to revoke. You did not do so. You waited. And on 8/8/2025, that prevention order initially passed for a period of 3 months ceases to operate. Meaning thereby, there is no prevention order on 9/8/2025. Then 9/8, 10/8, 11/8, and 12/8. There was no prevention order. Something has come to an end. So you are confirming an order which is already dead. That is the ground on which, one of the grounds, urged. Not to speak of that regarding your already detention, already in custody after arrest in connection with an NDPS case. But this is a ground that has been, we have been shown at least 3 judgments, 2 from the Supreme Court, 1 from our High Court.
Your Lordship,
Not to speak of other grounds,
Yes, Your Lordship.
that dialect, etc. Let us not go into that interpreter, because he needs an English interpreter. Similarly, he will need another interpreter for Manipuri also, Paume, Naga also, Nagamis also, because the script, except Manipuri, all are in English. ABCD, it has to be in ABCD. He does not know. Right. Then maybe we will not venture into for the time being.
That law, I was not served for copy, so I don't know.
These are settled law.
Your Lordship, on this, Your Lordship, para 9, Your Lordship, para 9 is my stand, Your Lordship, para 9 of the counter.
Counters. Okay, we'll read that. Defeating position.
It's at page 5.
Okay.
Counter variables were kept. मेरा counter bit कहाँ गया? Where is my counter?
The one file this morning. Okay.
Para 9.
Yes, ma'am. If I may be allowed to read.
Please.
Your Lordship, that statement made in paragraph 8.2 of the writ petition, the answering deponent denies the same and further states that the records will show that the detention order dated 9/5/2025 was served to the detainee on 13/5/2025 and acknowledge the same. Therefore, 13/5/2025 is taken as the actual date of detention of the detainee. Accordingly, 12/8/2025 will be the date of expiry of the first 3 months, as such that confirmation order dated issued on 11/8/2025, extending the detention period of the detention from 13/8/2025 till 12/11/2025 was issued before the expiry of the initial detention order. Your Lordship, in the confirmation order also, Your Lordship, the date, the specific date on which the
13/5.
it's mentioned, Your Lordship, in the confirmation date also.
12/8.
Yes, 12/8. So though he was already on custody, Your Lordship, he was officially detained on 13/8/2025, Your Lordship, on the date he was served a copy of the detention order, Your Lordship. So this date is counted, Your Lordship, not the order of the detention.
Supreme Court says this words, that is Article 22(4), these words put it beyond doubt that if the initial order of detention is not confirmed by the appropriate government within 3 months of the date of the detention, the detention after the expiry of that period ipso facto becomes unauthorized and illegal. They are not saying that, and more particularly, yes, this could have been a situation. You could have been, you could have argued that this man was at large. He had to be found out and picked up from some place where he is hiding, and thereafter is to be served. Though we passed the detention order earlier, but he was hiding somewhere in jungle. Oh, we have to go to the jungle and serve the detention order. It is not the case. You were all along aware that this man is in central jail. This could have been argued in a different scenario, but that is not there. You were very much aware because I'll take you. Proposal is, I think, is page 46. Page 46. Page 46 is a proposal. Page 47. page 47, last but few paragraph. The arrested accused Rongson Pomai has been forwarded to the court on 3/3/2025. After completion of 5 days police remand with a prayer for 15 days custody. Status of the accused. At present, the accused is in under judicial custody.
Yes, that's clear.
That is clear. While at the time of sending the proposal, you yourself was well aware that this man is in judicial custody, he is in this jail. Right? There is no whisper about, then at least detaining authority on 11th April. He cited one judgment of the Honorable Supreme Court and said that you are kindly requested to furnish the required information in the matter regarding his arrest, regarding whether he moved for bail or any likelihood of being released on bail. At least he had applied some mind at that point of time. Though the prevention order is silent on this aspect, but at least he made some.
On the ground of detention, nothing has been said.
Nothing, but at least he had some, applied his mind. What are the other grounds you have urged, Mr. Go?
On that, my lord, if I take her analogy on the date of serving, then in the confirmation was served to me only on 28, so 7 days.
Where is it? Any acknowledgement somewhere?
This is the only one which copy I have received.
No, in the records, it's 13, my lordship.
Okay, show me. Show me.
This is my copy.
Show me.
Even if 13 is
Go. Even if it is 13, go. Let us have the other line of argument.
From jail, they asked me to sign. This is my copy.
Let us see there. Even if it is 13, then it will go.
Then also it's gone.
In my affidavit is acknowledged.
Supreme Court said even a day, a second, it will be illegal detention.
Your Lordship, my annexure B.
Annexure B.
Page 3. Page 20.
That is
So this is the detention order acknowledgement.
Detention acknowledgement.
Detention order with grounds.
Five.
Your Lordship, you mean the confirmation?
yes,
the
yes.
confirmation.
Please. This is detention order. That was in 13.5. E3. Nine, 5. Is part of. Confirmation order is part of this. Annexure 1A. Have you stated so in the writ petition? Mr. Joe,
My lord.
regarding supply of the confirmation order,
Well, in advertisement, I have mentioned 13, but it is 2020. This is original.
but you have said 13.
Yes, madam. That was my technical mistake actually.
Which paragraph?
Lordship, with regard to that, I may be allowed to confirm from the authority because this record was already with me before the confirmation orders was passed, so they could not have annexed anything. So let me confirm that from the authority.
We are closing it, you give it tomorrow. We are closing it, otherwise. Can give you,
I can just make-
where is your original one? And which paragraph you were saying that 13.5? 13.5 or 13.8, you have said? And this is original at least. 13.5. 9.5. 9.5.
Well, you have signed very nicely in the
Yes.
English script.
And all the documents, Your Lordship, are signed.
Even then, there is a judgment. Even if you understand the smell and understand of English or anything, that will not suffice. There are a lot of judgments.
Now, where is that statement? That confirmation order has been communicated to you on
Well, page 9,
Yes.
8.1, 8.1. Last sentence one, last sentence. Actually, it was 20, but the typing is the one.
anyway, it still meets
Yeah,
the deadline for you.
Absolutely.
It still meets the deadline for you.
Absolutely.
If it is assumed to be 12.8, your their argument, then it ends on 12. If it is no, if the detention order is served on 12 or 13.5, then it ends on 12.8. Now you get the, if it is served, then on 12.8 itself, get the order. Otherwise, the original copy indicates.
Since they've already made a statement, yeah, I need to confirm. Your Lordship. I can just
Okay.
make a phone call, Your Lordship.
Oh, sure. We are here. No issue. You can have the information at 2 o'clock also. Okay, get the information 12 o'clock. We'll close it, but timing will pass the order after your.
Your Lordship, with regard to the language, Your Lordship, I would also like to place some citations.
Okay, we are not venturing into that.
It's not-
We are not, since in view of this position,
Yes.
we may not venture into that
Yes.
because
That's-
that may affect other cases also. We would not like to read that.
Another ground is my lord may kindly. In the detention order or ground of detention, there was no mention that the accused is likely to be released on bail. That is not reflected at all. There are a lot of judgments are given by law. Lordship also has passed away. We have given the judgment,
Please.
Lordship judgment. But there are more ground, but I think this is paragraph. Para 26, 27, 31, 33, madam. I have given the citation list. Para
26, 27.
26, 27, 31, 33. Lordship on that.
Yes, the Thoidrum Kanang Josi.
Wait, Rom, huh? Okay. We'll hear the next one. You go in the next one. Yes, Mr. You have anything to say? On the point argued.
I have nothing to say, Lordship.
Hmm?
Like, I have nothing to say, and there's no allegation because,
There is another requirement
yes.
under section 3, within bracket 2 of the PIT and NDPS Act, that as soon as you also You have to give the records. Before that, you find out from the records, right, this point. That as soon as a detention order is passed, either by a detaining authority, specially empowered, or by the state government, a report is to be sent to the central government within a period of 10 days.
As far as the timelines are concerned.
No, have you sent a report? Have you sent a report? Go through your,
As far as
no,
the
go through your record.
See,
Let us have it. Let us have a glimpse.
I have Xerox copies of it. So the report was sent on the same day, actually.
Okay, good.
Your Lordship, if you want.
Good. It is there. It is there.
Timeline, so we follow, we're strictly adhered to the act, Your Lordship, only on this part, Your Lordship.
Okay, you get the confirmation. Then we'll pass the order. Okay, we'll close it. Get the names for the respondents. AJO assisted by so and so and so and so and so. Please give the names.
Already just. Yeah.
Give it. Good. Hey, you do the print up later. Print up. Yes, here on the.
Yeah.
If something is common, we everybody
It can be common.
not combined, but copy. Okay.
Continue to.
Just only on that.
Only that point.
Only on instruction, whether it was served on 12/8 or 13/8. The other argument which has been developed by Ms. Inaholi will address on it. Here.
Yes, continue.
Service of the confirmation order on the detainee. Mr. Joe has averred in the writ petition on 13/8. By producing the original copy, he is submitting 28. 20. Now your
For admission, item number 4.
Please, your lordships. Lordships, I've moved an IA this morning, so.
Yes.
That can be taken up.
sure. What is so important about the IA?
Lordship, it's just for technical safety. My confirmation order has been passed.
Okay.
And I want to challenge that in the main petition also by, if I may be allowed to.
Confirmation order, 8 September.
Yes, your lordship.
8 September. Okay.
So if I may.
Where is your original detention order?
It's
5 June.
5/6.
5/6. When it was served?
On the 9th.
9. And you were in custody earlier?
Your lordship, in this case also, this is a clear-cut case of non-application of mine and errors apparent on the case of report.
5/6 detention order.
Yes.
5th June.
Yes.
When it was served, you were already in custody?
No, I was enlarged on bail. Why? Because.
No, on 5/6/2025.
Yes.
You were in custody or you were at large?
At large, your lordship.
You were at large?
Yes, your lordship.
Okay.
Why? Because
when you were taken into custody?
On the 9th.
9.
9/6.
Then confirmation order is on 8.
Yes, your lordship.
3 months from that point of view. Okay, let us have the any No counter.
In this case, my colleague Devika, she's appearing, so I was informed that there'll be
In view of this,
yeah, this IA lordship.
Hmm.
She's not present today, so it may be taken up next week, Your Lordship. Since I don't have the brief with me.
This preventive detention, there is a very
Yeah,
clear mandate.
whether in the bottom, Council is mentioned that you be adjourning a matter to.
You are planning to adjourn.
No, why? Because
If it has been submitted by you to the, or conveyed by you to the other side, then definitely they are not prepared.
otherwise, your lordship, this is a clear case where there's errors.
No, Mr. Council, it is a convenience.
Mhm.
If you have informed
Yes.
the counsel for the other sides that you will be making an prayer for adjournment while filing an IA, then in that case, they are not prepared perhaps.
Yes, your.
If that is the case, we'll keep the IA along with this one to be taken up in the next week.
All right, your.
Since Miss Libika is not here because of your information, she had gone out.
No, after she came to know that I'll be filing an IA, it was her, she who wanted me to adjourn this case. That's why.
So records are not here also. No counter also. Who is John? Okay, Mr. P. Warren,
Kohima.
learned counsel for the petitioner, has submitted that he has an interlocutory application, IA criminal number 30/2025 has been filed to bring the confirmation order as regards of the petitioner on record. A confirmation order dated 8/8/89. Post up. He has sought listing of the case in the next week. Poster. Ms. Sindaholi and State Council appearing for Ms. Libika, Learned State Council, has submitted that the necessary records regarding the detention proceeding will be made available on the next date of list. Poster. Mr. Yangarvati, Learned Central Government Council for the Union of India is present. Please the case on so and so. And the State Council shall ensure that the records of the detention proceeding is available on the next date. Since the state respondents have not filed any counter affidavit in this case, the state respondents shall also make an endeavor to file its counter affidavit on or before the next date of listing. This is the case on next week, Wednesday.
I'm okay.
For admission, item number 5.
This is also habeas corpus.
May I bless you, sir? Lord, I'm not just the instructions. So I'm for respondent number 4. Which is
You are Union of India. Who is the State Council? Records available. Yes.
Your Lordship.
It cannot go on, Mr. Anguli. You have to be fast in preventive detention matters.
my Lord, what the Bible.
Right.
3 of September 2025. So that takes some time.
Where is the preventive detention order? Oh, it was very recent. It was very recent.
No,
When notice was issued? 3/9. Without fail.
order was
Okay.
issued on.
Okay, records without fail. Okay. It is there. Where is the detention order?
Page 33. It was issued on 20th December 2024.
20th December.
Yes, Your Lordship.
You were involved in one police case registered under NDPS,
Yes.
correct?
Yes.
Then, so page 33. Page 33, 2012, 2024.
With
This,
regard to
this is under PIT NDPS.
Yes, Your Lordship.
Detention order. Okay, when you were served?
Since the
When you were taken into custody?
Yes, arrested on 8 of 2004, and since the detention order was made on 2012-24, since then, on that day onwards.
At that time, you were in custody?
Yeah, custody, yes.
Then when it was served, the copy was served on which day?
Communication was made on 21-12-24.
You have stated so?
Yes, on page 36.
Page 36. The detention order as well as the grounds of detention.
Yes, Your Lordship.
Okay, 21. Done. Then what did you do?
I made a representation.
Where is the representation?
On page 48.
Page 48.
On 5 February 2025.
1 minute. 5 February. Page 48. Okay, to whom?
To the Special Secretary, the Government of Nagaland.
Special Secretary.
From Department.
1 minute. 33. That was on which date? 5/2.
5/2/25.
1 minute. 5/2. What was the ground you have said? This is request to process forward the representing Special Secretary. Okay. Only to the detaining authority, to nobody else. Or copy to page 57.
Yes, Your Lordship.
Representation. On this page 57.
Copy
So,
of
to the detaining authority, to the state government,
yes,
to the advisory board.
Yes, Your
3.
Lordship. Yes.
Okay, it was done. Then confirmation order. Let us. Or 1 minute.
Page 65.
What is 63?
This is 63 is a reply.
Representation
Representation.
disposed
Yes.
by state government.
Yes, Your Lordship. And the memorandum.
Disposed by state government.
Page 64 is the memorandum issued by the Union government.
That was on 7th February. February 6th. 62. T4.
TPS 65 and 66.
When is the advisory board opinion?
It was on 6/3/2025.
6/3. Ms. Sinaholi, please come to page 65 and 65A of the writ petition.
65.
Confirmation order.
65 is you are extending it for another period of 3 months. Right.
Yes, Your Lordship.
So in essence, it is not confirmation order.
Your Lordship, the confirmation is.
No.
Yeah.
Please stick to one by one. Don't jump. Page 65.
Yes, Your Lordship.
This, we read that this authority had the advisory board opinion. Right?
Yes, Your Lordship.
Because paragraph 3 is of the opinion. But he decided to extend it for a further period of 3 months, within which period the detention will be reviewed as per the provisions of PIT and NDPS Act. That is what he is saying. Then turn over to the next page. Now here by this order, he has extended it for another period of 3 months, but it is in exercise of 9F. Right. 9F is confirmation. Right. So explicitly he has exercised that power by that document 65A,
Yes, sir.
9F. Whether the earlier order was also 9F.
Yes, Your
9F.
As per the order, yes.
Confirm the so and so. Okay. Then, he's extending it by 3 months, 3 months. That is what, okay. So all the representations were disposed of
Yes, Your Honor.
by detaining authority,
Yes, Your Honor.
by the state government, and also by the central government.
Yes, Your Honor.
And that period is within a detaining authority within 1 day, state government within 2 days, and the central government within a period of 1 month.
Yes, Your Honor.
They have disposed of your representation. Now, what is your ground of challenge?
The basic ground you were giving under Paran number 10.
Tell us.
That there is a violation of procedural safeguard at the time of seizure.
Seizure is in the NDPS case.
Yes, with regard to this, at the time of.
That is a matter of trial of that NDPS case. Don't bring those into this matter of preventive detention. You argue that for your acquittal or
Yes,
discharge. Don't bring that into this matter of preventive detention. Okay, we'll take up at 2. At 2.
Original recording of seek your lordship's indulgence.
Hmm.
Earlier, I had overlooked this matter on item 20 from the hearing list, your lordship. This matter is handled by Shukre, your lordship. So this may kindly be listed after 2 weeks as well.
Item 20.
Yes, from the hearing list.
Who is the council? Senti anger.
Your lordship. Yeah,
Council has been taken.
counsel has been taken.
Item 20 of similar report in only on behalf issue free consent 2 weeks.
I'm trying to compare. Okay, but item 3, the instructions, your lordship, I had.
Item 3. Not mine.
To your lordship, verbal information. It has been confirmed that the document which is the petitioner is submitted is correct, your lordship.
20.
So 20.
20.
Confirmation order served on 28.
28.
Okay.
Madam. Madam.
Let us attempt which we are continuing.
This is item 5. Item 5.
In a NDPS case, when you were arrested,
8/8/2024.
NDPS case. 8/8. Where is the document? Arrest surrender memo. Time of arrest. 9/8. 9/8.
FIR was made reminder as per the report.
No, this is arrest memo,
Yes.
page 25. Okay. Arrest memo. When you were released on bail, where is that?
Bail was yet to apply.
Huh?
Bail is yet to.
That has been, that I have been asking from the very beginning. Whether you were released on bail or not, you say you were saying that.
I was in
You said
custody.
you are at large.
You were at large, you were at large.
No, that is different case.
Oh.
Yeah, the preferred case has been. That is the.
No bail
With regard
preferred.
to this case, there is no bail. I did not avail any bail.
What is the case number? In this, okay, in the 13 of 2024?
Yes, Your Worship.
Tell me specifically. Did you apply for bail or not apply for bail?
No, not apply. Since I was under detention, I did not apply.
And they have mentioned somewhere that you were in custody?
Since the arrest, I was in custody.
Yes. Ground of arrest. Was arrested. Following the procedure. Investigation transferred, unknown person. Status of arrest, judicial custody. Madam, do you have the PIT NDPS Act? Let us read the section 10 together.
Cases in which circumstances under which persons may be detained for a period longer than 3 months without obtaining the opinion of the advisory. Notwithstanding anything contained in this act, any person, including a foreigner, in respect of whom an order of detention is made under this act, any time before the
At any time before. Right, this is important. 31st of July 1999. Yes, continue.
may be detained without obtaining, in accordance with the provision of subclause A of clause 4 of Article 22 of the Constitution, the opinion of an
This
advisory.
is regarding that the previous case, right? 3 months, 3 months. Okay, continue. The opinion.
The opinion of an advisory board for a period longer than 3 months must not exceeding 6.
But not exceeding 6.
Yeah, sorry. But not exceeding 6 months from the date of his detention. Where the order of detention has been made against such person with a view to preventing him from engaging in illicit traffic in narcotic drugs and psychotropic substances, and the central government or any officer of the central government not below the rank of an additional secretary to that government, specifically empowered for the purposes of this section by the government, it is satisfied that such person engages or is likely to engage in illicit traffic in narcotic drugs and psychotropic substances into, out of, through, or within any area highly vulnerable to such illicit traffic, and makes a declaration to that effect within 5 weeks of the detention of such persons.
2 conditions. One is before 31st July 1999, right? And second, and after end, the central government or any officer of the central government, not below the rank. He has to satisfy that so and so. Then explanation 1. Say, leave aside Roman 1, 2, 3, 4. Now come to 5. C. India-Burma border in the state of within 100 kilometers, right? Explanation 2 is custom station. Now, all this detention, this section 10 is meant for any detention order passed before 31st July. But you are still making mention of it in every detention order. Come to page 39. Of the petition. You will see grounds of detention, right? C3, as per section PIT NDPS, Nagaland is an area vulnerable to such illegal traffic, therefore requires extra caution to prevent the illicit. This section is meant for period earlier to 31st July 1999. We are in 2024 and 2025. You are still using that provision as if it is applicable to the state of Nagaland. Am I clear?
Yes, sir.
And with that impression, you have passed this order on the page 65 pass. Anyway. So he was in jail.
Yes, Your Lordship. She.
She?
Yes.
Okay, she.
Yes, Your Lordship.
Okay, she.
She is a mother of 4 children.
Lam Khonsei Khonsai. Huh?
Lamkun.
Lampolilis Khonsai.
Khonsai.
Resident of Manipur.
Yes, Your Lordship.
Hmm.
She is a cookie.
Hmm. 160. Any charge sheet has been submitted?
Charge sheet in the NDPS case?
No, not yet.
Madam, suo motu affair is there. Page 46. Four persons were apprehended. Any preventive detention order is passed?
Chip, as far as information, the first one, R. Ponga, Chip,
Against him also.
yes.
Let us have a look at your records. He is already in jail.
He's in jail,
Where
yes.
could he send people? What is the need for preventive detention?
There substantive that where to end this charge sheet was filed. No, sorry, she was on depression. But
As per your own proposal, she understands only Kuki and Manipuri. As per your own proposal, she understands only script, Kuki and Manipuri, not English.
Your Lordship, if I may seek your Lordship indulgence. In the earlier case, I first received the information that the acknowledgement, which is dated 28, is through post. But there's another acknowledgement on 13th itself, Your Lordship. It was served on the first day. I'll download this and ask.
Please, please.
Reading this. But nothing is stated in the detention order.
Where was the real possibility of him being released on bail? Because he did not prefer any application.
It's so much, but.
Is it not? Where is the real possibility to reach the subjective satisfaction that he should be preventively detained? This is the only question.
Lordship may also take into consideration that in paragraph 19 of the writ petition, the petitioner himself has stated that he was on the verge of getting default bail. Lordship.
That is subject to failure of the investigating authority. Subject to failure of the investigating authority. It is not automatic. This default bail will be subject to failure within the stipulated time of 90 days. She is with commercial quantity?
Yes, sir.
Commercial.
Yes, sir.
Then this section rigors of 37 will come. Section 37. If he prefers an bail application, opportunity to the public prosecutor, then privacy case, rigors of 37. And default bail on the failure. Just because you are going to fail, you cannot invoke this drastic action of preventive detention. You are fully sure that we are going to fail. So let us invoke Section 3 of the PIT NDPS. That appears to be the case because there is no discussion on real possibility because he did not even file a bail application seeking her release on bail. So that real possibility on the date when the preventive detention order has been passed, that was absolutely absent. And that is a future one, default bail. And default bail is always subject to the condition that in the event charge sheet is filed, then it will be always on merit. And during the course of investigation, also, it is always on merit, except the failure. So anything you have to say, this is the only issue here. Let us assume for a timing that, and before the advisory board, she clearly said that I understand only, I do not understand English. Who?
Gamis also.
Translator was there.
Or translator was also there. So that makes it clear, case is clear. And in your own proposal, you said she understands. I have already said to you, in your proposal. Let us see. And you have served, took her signature. You did not even bother to translate the contents, not to speak of translated copies. Everything is in English. Everything is in English. You have served all the copies, that we must say, but at the same time, where is a proposal? A proposal. Proposal.
Which to be
Somewhere it is there.
38.
38. Language.
Regarding the language.
Regarding the language.
Page 42. Page 42. Number 14.
Number
14.
14.
Languages speaking only to the.
Kuki Manipuri.
Okay.
It is clear.
So, Your Lordship, and also, Your Lordship,
Please.
here the petitioner has already submitted a representation, Your Lordship. So that will also mean there's an effective representation, Your Lordship.
That I say.
If you go by the representation also, Your Lordship, it's clear that she understood everything, Your Lordship.
We are on the reaching of subjective satisfaction by the detaining authority. Law is settled. We need not have to lay down the law. We have to follow the law. The question is the real possibility of being released on bail. Everywhere you have mentioned she is in judicial custody. And there is clear order sheets are also there in the record. Nowhere it is reflected that she had preferred any bail application. Then subjective satisfaction by the detaining authority that she is likely, there is real possibility of being released on bail. That satisfaction has not yet been received, has not been reached, not even discussed. And law is settled. As annexed, if you go through the judgments referred to, let us come to 163. That withdrawn Konungjao Singh, right? Quoted. Para 9 quoted. There was reliable material before the said authority on the basis of which it could have reasons to believe that there was real possibility of his release on bail. And further on being released, he would probably indulge. This is anticipation, second part, but first part. First part, that was not there. It was after the detention order passed on 20/12/2024, right? This writ petition was filed, I think, in August, after 8 months. Detention order was in December 2024. This petition was filed in
Actually,
August.
the petition was moved earlier. They had withdrawn 2 times. So
Because of ongoing,
it was not the on.
because of the ongoing conflict in Kangkopi. Between
The file on the first September. Yeah, only surprise. You know.
The first one, Your Lordship, I would like to write on 1974 for SCC 503, Your Lordship, para 4, Your Lordship. It is also contended that the petitioner is illiterate, and since the order of detention was not explained to him only in his own language, he had no opportunity to make an effective representation. The affidavit of the Deputy Secretary shows that the vernacular translation of the detention order was applied to the petitioner on the very day that the order of detention was served to him. Besides, the petitioner had made his representation to the government and has also appeared in person before the advisory board. It cannot therefore be said that the petitioner was not aware of the nature of allegation made against him. And Your Lordship,
Vernacular translation.
yes, in this case, though, it was given, Your Lordship.
It was
But
given, it goes against you.
Yes, yeah, like Your Lordship had said, Your Lordship, he's illiterate. Even if I give the vernacular also, you'll not understand, Your Lordship.
No,
Because the script is.
no, your own proposal says, page 38 or what?
42.
Page 42. 14.
moreover,
Language and script known to the proposed detinue. Script,
and this is
language and script. Your own proposal, page 42. Already petition, seal number 14.
But
Let us not believe,
cookies is the first language.
let us not believe the petitioner. Then your own proposal, your own investigation says that language and script known to the proposed detinue.
Your Lordship, the petitioner is a cookie, so Your Lordship. So cookie script, it's in English, Your Lordship, English script. So Your Lordship.
And Manipuri?
I think it's
Bengali?
Different script.
It's a different script, actually. And
It is a Assamese or mixture of the Assamese and Bengali.
Your
So
Lordship,
vernacular translation was not done.
so
That is one, okay.
the second, 1985,
Yes,
so what, I would like to rely on 81, 82,
81,
83, Your Lordship.
81.
Though in this case, the vernacular translation was given, Your Lordship, I'd just like to rely on the principle that
There are 81,
82 and 83, Your Lordship.
81.
In this case, 81. In this case, there was evidence before the authorities concerned that 60 gold biscuits of foreign origin without any explanation of the importation was found in the possession of the father. That is undisputed. Veninal could not give any explanation of their being in their possession. These were smuggled. Secondly, there was evidence in view of the subsequent other facts independent of the confession of the father and the sons of and the daughter that the father was in contact with persons who were buying smuggled gold from him and buying at high prices. Their telephone numbers were found and they could be identified from the papers seized during the search at his hotel. The detenue Venila made a mercy petition. As the statement of objects and reasons of 1975 Amending Act states that smuggling of foreign exchange, racketing, and related activities have a deleterious effect on the national economy and thereby a serious adverse effect on the security of state. The society must be protected from the social menace of immobilizing the person from detention of the person engaged in those operations and to disrupt the machinery established for furthering smuggling and foreign exchange manipulations, such and such. Preventive detention, unlike punitive detention, which is to punish for the wrong done, is to protect the society by preventing wrong being done. Though such powers must be very cautiously exercised, not to undermine the fundamental freedoms guaranteed to our people, the procedural safeguards have to be ensured that yet this must be looked from a pragmatic and common sense point of view. The exercise of the power of preventive detention must be strictly within the safeguards provided. We are governed by the Constitution, and our Constitution embodies a particular philosophy of government and a way of life, and that necessarily requires understanding between those who exercise powers and the people over whom or in respect of whom such powers is exercised. The purpose of exercise of all such powers by the government must be to promote common well-being and must be to subserve the common good. It is necessary to protect, therefore, the individual rights insofar as practicable, which are not inconsistent with the security and well-being of the society. Grant of power imposes limitation on the use of the power. There are various procedural safeguards, and we must construe those in proper light and from pragmatic common sense point of view. We must remember that observance of written law about the procedural safeguards for the protection of the individual is normally the high duty of public official, but in all circumstances not the highest. The law of self-preservation and protection of the country and national security may claim in certain circumstances higher priority. As has been set out by Thomas Jefferson, to lose our country by a scrupulous adherence to written law would be to lose the law itself, with life, liberty, property, and all those who are enjoying them with us, thus absurdly sacrificing the end to the means. By the aforesaid approach, both justice and power can be brought together, and whatever is just may be powerful, and whatever may be powerful may be just. So, Your Lordship, in this case, the timeline has been strictly adhered to, Your Lordship.
Yes,
So,
timeline, yes, no doubt about it.
Yes, Your Lordship. So this,
That I have said already, that timeline you have adhered to, and plus representations were also disposed of within the as early as possible. That we have to say.
Consider lapses, Your Lordship. Hold on.
But there is the most vital thing for preventing a person is that real possibility. That is absent. And everybody knew that this lady is in custody. And custody since 8/8/2024. So there is another factor. Last activity, last alleged activity, she indulged in August, and you slept. In after 4 months, you got awake. That live and proximate link is also snapped. But we are not into it. We do not go. We have already held. Already live and there must be existence of live and proximate link. That yes, real possibility. That is missing. Anyway.
Please, even with regard to the acknowledgement certificate provided in the affidavit position, it does not indicate that a particular person has translated the
Which one you are referring to? Which document?
opposition in affidavit.
Opposition, there is no affidavit in opposition.
They have not filed. Oh, you have filed?
Yeah.
Who is that?
Oh, let's see.
Okay, it is there.
The annexure.
Okay.
The acknowledgement certificate does not provide the person who has translated. So this acknowledgement slip is also.
It is not there. It is said the contents have been explained to me in the language I understand. The certify that the contents have been explained to me in a language I understand, Manipuri, in presence of the understated witnesses. Is it your ground taken that copies were not provided in a language understood
Yes,
to me?
I've been already.
You have taken a ground?
Yes, I've taken the ground.
Okay.
And moreover, this criminal antecedents, no habitual, she was not the habitual.
This is your first time?
Yes.
First time arrest?
Yes, Your Lordship.
First time?
First time.
They had extracted in your 161 statement that I was involved. Violating Article 20, subclause 3. Nothing can be accepted when a person is admitting something in custody against himself. You know Miranda rights.
Sorry, Your Lordship.
Miranda rights. You Google it. Miranda rights, American concept. That has been brought in the Constitution. Article 20. Heard, Mr.
Jasi Tole.
Land Council for the petitioner. Mr. of Miss Ina Holi. Land Senior Government Advocate. Land Government Advocate for the respondent number 1, 2, 3, and Mr. N.Z. Anguli. Jed Anguli. Jed Anguli, Land Central Government Council for the respondent number 4. Comma Union of India. And the arguments are heard. That has been discussed.
For admission, item number 6.
Yes.
Yes, Your Lordship, this appeal is against judgment wherein the petition of the appellant has been dismissed on the ground that it is not maintainable, as the petitioner, having participated in the selection process, could not have turned around and challenged the selection of the respondent of the family.
Today it has come for what?
It is a fresh appeal.
First appeal.
Yes. So,
should we go into the merit?
No.
Right at the beginning?
I'm afraid the notice may be issued on our file.
Okay, who is for the state, Miss Ina Holi? Would you accept? There is a private respondent.
Yes.
Heard Mr. L. Iralu, Land Council for the petition, and Mr. MT.
Why?
Sorry.
For respondent number 1
Learned
to 4.
Senior Government Advocate, Nagaland, for the respondent number 1, 2, 3, and 4. Post up. This intercourt appeal is preferred against a judgment and order dated 8/8/2025. Passed in a writ petition, command WBC number 222/2024, wherein the present appellant was the writ petitioner.
Yes.
First of all, by the judgment and order dated 8/8/2024, 5, the writ petition preferred by the appellant petitioner was dismissed. First of all, issue notice returnable 4 weeks, as Mr. Imchen, Senior Government Advocate, has appeared and accepted notice on behalf of the respondent number 1 to 4.
No.
Issuance of formal notice to the said respondents is dispensed with. The Learned Council for the appellant shall, however, furnish requisite number of extra copies of the writ appeal and novel annexure to Mr. Imchen within 3 working days from today. The appellant shall take steps for service of notice upon the respondent number 5 by registered post with the AD within 3 working days from both.
For orders, item number 7.
Yes,
May Lordship, on the last occasion, the Honorable Court appointed an MES query to represent the respondent, and we have served a copy to the MES query as per the Honorable Court's direction, Your Lordship.
1 minute. This is an appeal against conviction.
Yes, yes, Your Lordship.
Under what section? Under what section?
Under section 4 POSCO and under section 8 of POSCO Act.
Section 4.
Yes, Your Lordship.
Section 4. Sentence.
Sentence 20 years.
20 years.
And under section
Who is
8 of
for the appellant? Who is for the appellant?
He's appearing for appellant.
You are for the appellant?
Yes,
Who's the appellant?
Lordship, I have
One,
permission to make.
you are for the appellant. You are for whom?
I am for a complainant. I was on the last,
Okay.
on the last occasion, I was.
You are for a
appointed-
victim.
Yes,
Victim.
no, Lordship, the complainant.
Victim complaint.
Victim complainant.
Victim stroke
So,
complainant.
Lordship-
Okay, and you are for state. Okay, there is an I.
Yes, Lordship.
Now, an opportunity is to be granted in case of POXO offences to the public prosecutor as well as the victim or complainant to file their objection if
Yes.
they so choose.
Yes, Lordship.
And if they waive their right, we will go on deliberating on the IA. What you are intending?
Lordship, if I may make a submission. Lordship, on the last occasion, I was appointed as a legal aid counsel for the
Okay.
complainant.
Okay.
So I have tried to make contact with the complainant. We have been making efforts, but it's still yet we are unable to make contact with.
What documents you have been provided with? as
I have the
legal-
memo with me. I have the IA also with me. But I
Okay.
want to file an objection to the IA.
Okay, you can
That's
go
why-
through the case records.
Yes, Lordship.
Do you have the paper book?
I have the paper book, Lordship.
Okay, you have the evidence
Yes, Lordship.
with you,
Yes, Lordship.
testimony of the witnesses.
Yes, Lordship.
So on the basis that you can file,
Yes, I can, but we need the signature of the complainant, so that's why we are making an effort to.
okay, how much time?
At least.
That by what time your efforts will be?
2 weeks time, maybe.
2
Lordship.
weeks.
We can try.
Yes, Mr. Counsel, for the appellant,
Oblige, your lordship.
heard Mr. Jed Khalid,
Yes, your lordship.
learned counsel for the appellant who has appeared virtually. Miss S. Mere, learned public prosecutor, for the state, and Mr. Crucio Longkumar, T. Longkumar, learned legal aid counsel who has appeared for the respond number 2, that's informant stroke, that's complainant or informant. It is a police case?
Yes,
It was a police case, also. Yes, Miss Mary, you are the main person, whether you want to file any objection or not.
Yes.
Not, state is not filing. We find it strange. In principle, in every case.
In every case, they are filing. Yes.
We find that waiving the rights. Also, because there is a notification already from the principal seat which is applicable to you.
If that's the case, Lord.
Both Miss Mary, as sought for by, both Miss Mary and Mr. Kumar have been granted 2 weeks' time to file their respective written objection to the instant application filed on behalf of the applicant under section 430. We didn't make it 2 BNSS stroke 430 BNSS stroke 389 CRPC. Also, list the case after 2 weeks. List the appeal.
For orders, item number 8.
May I please, Lordship.
Yes, why I?
My lord, in 2017, 2 accused persons were convicted by the session court Mon. But these 2 accused persons, they could not file appeal maybe because of financial difficulties. So subsequently, the Legal Service Authority of High Court had appointed me as amicus curiae. So I prepared everything, I settled the appeal, everything. Then I sent down the appeal through my junior to get signature from jail and get endorsement from jail. But unfortunately, I did not cross-check after filing. So only on 6/8/2025, when the matter was listed for hearing, I cross-checked, I came across the mistake.
Which page?
Affidavit.
Which page?
So, Lordship, affidavit.
Which page?
Affidavit of the appeal memo. So for that, I sought the permissions of this High Court on 6/8/2025. And this court was kind enough to allow me to rectify the FLV, my lord. My lord, page 8.
I think, do we have the High Court rules?
So I have.
No affidavit is required from you, but there has to be a. Have you gone through the criminal rules and practice? Because there has to be a certificate, not affidavit.
I have no option, so I read to the court to rectify the
1 minute.
FLV.
Let us play by the rules.
My lord.
I'm never.
As far as I know, appeal accompanied by a certificate.
Certificate. That good grounds, I have taken good grounds, all those stuff.
Yes.
Let us have this criminal appeal. General procedure. Writ petition. Appeal to the Supreme Court. Criminal business appeal 125.
Normally advocate certify.
Yes.
Ah.
See the previous one. Previous one, which appeal, criminal appeal. Item number 7. No, this is the certificate. This is the certificate.
Certificate by the
That I so and so do have a certificate that the grounds set forth in the connected criminal appeal are good grounds of law for appeal. That is the certificate required.
That's what I realized.
No affidavit, no notary, nobody is involved. So this particular I is also right. We grant leave to file the certificate. That's all. And Mr. A. Joel and counsel for the applicant, appellant, and Mr. N.
My name is Amicus Curiae, maybe different.
Oh, Leonard Amicus Curiae for the applicant, appellant, and Mr. N. K. Angami. Leonard, public prosecutor for the respondent state. Full stop. The instant interlocutory application has been preferred on behalf of the applicant, the appellant, seeking leave to rectify the affidavit dated 3/7/2020, sworn in support of the appeal by the applicant appellant before the notary public. Full stop. Mr. Joe Leonard Amicus has submitted that. Has submitted that the memo of appeal is required to be accompanied by a certificate from the council for the appellant in a criminal appeal. Memorandum of criminal appeal করে দিও। Post of. He has sought leave to append such certificate to the memorandum of criminal appeal already filed. Mr. Angami, Land Additional Public Prosecutor, has submitted that he has no objection to the leave sought for on behalf of the applicant appellant. Full stop. While disposing of, will not say this thing, while disposing of the instant interlocutory application, we deem it proper to grant leave to the learned amicus curiae to append a certificate to the memorandum of criminal appeal already filed within a period of 1 week from today.
My apology.
For orders, item number 9.
The certificate, the application is also long. Yes.
This orders IA is for continuation of leave.
How much?
1,010 days.
Only. What is the period of delay? Oh, sorry. What is the sentence?
Sentence is life sentence.
Conviction under
302.
302.
Yes, Lordship.
And when you were appointed?
Lordship, I was appointed.
26 June 2025.
Yes, Lordship. Yes.
Okay. And what he did not prefer any appeal?
Yes, Lordship.
The
reasons I have stated in paragraph number 3 and 4.
Yes, Mr. Angami. Do you have any objection? When substantial justice and technical considerations are pitted against one another, it is the substantial justice.
Lordship, if the matter may come up next week, actually, we have endorsed our colleague, Mr. Jimobi, that if everything is with him.
It is you or anybody else.
So,
Scenario will not change, but at least the hearing of the appeal will be expedited by 1 week.
Yes.
Lordship,
This is a criminal appeal. Had it been a writ appeal, we would have straightaway dismissed it.
This is in that case, so allow me to leave it to the discretion of my.
Okay, heard. Mr. T. Longkumar, learned legal aid counsel, appearing for the applicant appellant. And Mr. K. Angami. Angami, no, N or K, I always get confused.
Yes.
K. Angami, learned.
K. Angami. The one with the little hefty ones.
Learned public prosecutor for the opposite party, the respondent state of Nagaland. Post of. The instant application under Section 5 of the Limitation Act 1963 is preferred, seeking condemnation of delay of
1,010 days only.
1,010 days, which have occurred in preferring the accompanying criminal appeal. Full stop. The accompanying criminal appeal, which is a memo of appeal, under section 415 within bracket 2, Bharatiya Nagorik Puraksha Honita 2023 is preferred against a judgment and okay, it was stroke 374 within bracket 374 CRPs has been is preferred against a judgment and order. Judgment dated 3/10/2022 and an order on sentence dated 10/10/2022 passed by the Court of Learned Sessions Judge, Nagaland, in ZR case number. Where is your judgment?
16.
In ZR case number 16 of 2021, which arose out of Handari Police Station case number 01/2021. Full stop. By the judgment and order, the applicant appellant has been convicted for the offense under section 302, Indian Penal Code, and he has been sentenced to undergo imprisonment for life. Post of para. It has been averred that after the impugned judgment and order of conviction and sentence, after delivery of the impugned judgment on the applicant appellant was taken into custody, and since then the applicant appellant is in incarceration. Full stop. It is further averred that the applicant appellant did not have the means to prefer an appeal, as he has not been advised. Further, he has not been advised. Further, he did not receive any proper legal advice to prefer an appeal. First of all, it has been submitted by Mr. Longkumar that there are good grounds to prefer an appeal against the impugned judgment and order of conviction and sentence. Post stop. He has further submitted that it was only on 26/6/2025, the Nagaland State Legal Services Authority had appointed him to prefer an appeal on behalf of the applicant appellant. Post stop. As during the interregnum, the applicant appellant did not prefer an appeal due to the regions assigned, apparently paralegal. We find that the applicant appellant has made out a good case for condoning the period of delay. Sentence. Additional public prosecutor has fairly submitted has fairly submitted that has fairly submitted that the court may exercise the discretion appropriately in the case in hand. Submission delay, registry to register the accompanying criminal play and thereafter to release the case for admission in the next week. Delay or no?
But this may be issued to the complainant
after registration of the appeal. That is why I have said.
Then admission. Then admission stage.
We have expedited it.
For hearing, item number 16. Hearing?
Yes, what kind of hearing? Any long hearing? Appeal is admitted for hearing. Yes. Long hearing. Because we have two habeas corpus petition to decide. So we have how much time it will take? Tell me.
It will take some time, my lord.
Is it so?
Yes. Because there were as many as 3 petition proceeding. And this will be the fourth.
Oh.
If it the
can it be on some other days?
My lord.
Mr. Longchar?
My lord. I'll take only 10 minutes.
But he will take
I don't like
5 times more than you. Some other day, we fix a date. Yes,
Next week or so.
next week.
Malo.
Okay, empty long shirt, land council for the appellant. And Mr. Mohan Chen, land senior advocate for the respondent 1 to 6. There is no private respondent?
No.
Good. Present as sort for land council for the parties, leaves the appeal on next Wednesday.
Much.
But let us finish the
It is a
Preventive.
matter now. I'm satisfied.